Many states determine the order of water rights according to which users of the water hold a recorded beneficial use permit. This allocation of water rights is determined by A. Accretion, B. Riparian theory, C. Literal theory, D. The doctrine of prior appropriation. Answer, D. All terms relate to water rights, with riparian the right to use water adjacent to one's property being the most common in sections of the U.S. where water is abundant. However, in states where water is more scarce, a form of prior appropriation applies. Also known as first in time as first in right, it grants water rights to divert a specific amount of water from a specific source to irrigate a specific piece of property. Those rights are then assigned a priority based on when the right was first used or applied for. In periods of peak demand, they give those whose claim is the oldest the right to get their water first. The right to control one's property includes all of the following except A. The right to invite people on the property for a political fundraiser. B. The right to exclude the utilities meter reader. C. The right to erect no trespassing signs. D. The right to enjoy pride of ownership. Answer, B. Answer, B. This right to enter and work on a property is granted to utility companies, water, sewer, gas and electric, as well as telephone and cable companies. Essentially, if a company provides a service and owns the equipment, for example, phone and cable lines, they are usually granted an easement. Which of the following types of ownership cannot be created by operation of law, but must be created by the parties' expressed intent? A. Community property. B. Tenancy in common. C. Condominium ownership. D. Tenancy by the entireties. Answer, D. Tenancy by the entireties is a form of ownership that husbands and wives can choose or create by deciding to do so and declaring it as such in contracts and deeds. Tenancy in common is put in motion by state law. Community property is a law of ownership that exists in Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington and some other states. Tenancy by the entireties is an estate that is recognized in some states between husband and wife, who have equal right of possession and enjoyment during their joint lives and with the right of survivorship, that is when one dies, the property goes to the surviving tenant. Which of the following is / are considered to be personal property? A. Wood-burning fireplace. B. Furnace. C. Bathtubs. D. Patio furniture. Answer, D. The concept of personal property typically comes into play at the time of sale. Things that are part of the house: bathroom fixtures, fireplaces, carpeting and such go with the sale. Unless specifically excluded, as can happen in the case of a dining room chandelier or one or two other objects with which the owners have an emotional attachment. Furniture, rugs, lamps and other portable items that are not nailed down constitute personal property and are not included in the sale. The word improvement would refer to all of the following except A. Streets. B. A sanitary sewer system. C. Trade fixtures. D. The foundation. Answer, C. The term trade fixture refers to an item installed by a tenant in a rented commercial property that he or she removes at the end of the occupancy. More on this topic follows. All of the following are physical characteristics of land except A. Indestructibility. B. Uniqueness. C. Immobility. D. Scarcity. Answer, D. Scarcity is a fundamental economic concept that holds that the rarer and more desirable something is, the more valuable it will be. For example, professional athletes are highly paid because only the smallest percentage of people have the ability to perform at that level. Land is scarce because there is a finite amount available and, as Will Rogers once said, they ain't making any more of it. Certain items on the premises that are installed by the tenant and are related to the tenant's business are called A. Fixtures. B. Emblements. C. Trade fixtures. D. Easements. Answer, C. The term is usually applied to a commercial tenant and refers to items installed in connection with his or her business, such as stoves and refrigerators in a restaurant or display cases in a retail shop. Personal property includes all of the following except A. Chattels, B. Fructus industriales, C. Emblements, D. Fixtures. Answer D. Chattel is a legal term that means personal property. Emblements and fructus industriales refer to profit from crops that are grown as a result of a person's labor, such as corn, as opposed to those that occur naturally, such as grass or minerals. By the custom of English common law, they are considered personal property. By contrast, a fixture is considered attached to a property and thus part of the structure. A person who has complete control over a parcel of real estate is said to own a leasehold estate, B. Fee simple estate, C. Life estate, D. Defeasible fee estate. Answer B. All the other options have conditions attached. A leasehold estate is, as the name implies, leased property. Similarly, a life estate gives a person ownership or control of a property only for the duration of his or her natural life. Defensible estates give a person or entity control over a property only so long as certain conditions are met or avoided. For example, a community might be deeded a property on the condition that it be used only for building a school, or land willed to a child on the condition it never be used for commercial development. If the community tries to use the property for a recreation complex or the heir tries to sell to a retail developer, control would automatically revert to another party and the deed would become void. A portion of Wendell's building was inadvertently built on Ginny's land. This is called an A. Accretion, B. Avulsion, C. Encroachment, D. Easement. Answer C. The principal attributes of an encroachment are 1. It is accidental and 2. It involves only part of a structure. Typically, the issue would be resolved by selling Wendell an easement or a lease or, if practical, actually moving the structure. The purchase of a ticket for a professional sporting event gives the bearer what? A. An easement right to park his car. B. A license to enter and claim a seat for the duration of the game. C. An easement in gross interest in the professional sporting team. D. A license to sell food and beverages at the sporting event. Answer B. Easements grant access, not use. Commercial licenses, such as those required to sell beverages, souvenirs or services, cover extended periods. Although tickets to sporting events, concerts, shows and the like are technically licenses, they differ from most in their degree of restriction. For example, a concert ticket does not give the bearer the right to sit anywhere he or she chooses or wander backstage to meet the performers. If the owner of the dominant tenement becomes the owner of the servient tenement and merges the two properties, what happens? A. The easement becomes dormant. B. The easement is unaffected. C. The easement is terminated. D. The properties retain their former status. Answer C. Dominant and servient tenements involve two adjacent properties in which an easement is involved. For example, let's say Bridle Creek Farms and Barnstable Farms are separate parcels divided by a country lane that provides access to the county road system. The lane is owned by Bridle Creek, but the deeds of both properties stipulate that Barnstable Farms shall have unrestricted access for the purpose of accessing county roads. That access is an easement. Thus, if the owner of Barnstable Farms buys Bridle Creek Farms, the need for the easement disappears. Homeowner Ginny acquired the ownership of land that was deposited by a river running through her property by A. Reliction, B. Succession, C. Avulsion, D. Accretion. Answer D. Accretion means the addition to a parcel of land by sand or soil deposits due to the action of a river or other body of water over time. Avulsion refers to the loss of land as a result of its being washed away by sudden or unexpected action of nature, such as a flash flood that reroutes a river. The rights of the owner of property located along the banks of a river are called A. Littoral rights, B. Prior appropriation rights. C. Riparian rights. D. Hereditament. Answer, C. Literal and prior appropriation are different kinds of water rights. In the first case, navigation rights to an ocean or other large body of water. In the second, the right to use a water source for irrigation. A hereditament is any inheritable property. The local utility company dug up Frank's garden to install a natural gas line. The company claimed it had a valid easement and proved it through the county records. Frank claimed the easement was not valid because he did not know about it. The easement A was valid even though the owner did not know about it. B was an appurtenant easement owned by the utility company. C was not valid because it had not been used during the entire time that Frank owned the property. D was not valid because Frank was not informed of its existence when he purchased the property. Answer, A. Easements grant only access, not ownership, use or occupancy rights. Further, that access is generally for the benefit of the property owner, such as maintaining utilities or sidewalks. As such, they attach to a deed or lease and remain in effect until specifically lifted. 16. Jim and Sandy are next-door neighbors. Sandy tells Jim that he can store his camper in her yard for a few weeks until she needs the space. Sandy did not charge Jim rent for the use of her yard. Sandy has given Jim an what? A. Easement appurtenant. B. Easement by necessity. C. Estate in land. D. License. Answer, D. Granting the use of property for a defined period for a specific purpose is almost always a form of licensing. Easements grant only access, not ownership, use or occupancy rights. Further, that access is generally for the benefit of the property owner, such as maintaining utilities or sidewalks. Your neighbors use your driveway to reach their garage on their property. Your attorney explains that the ownership of the neighbor's real estate includes an easement appurtenant giving them the driveway right. Your property is the A. Leasehold interest. B. Dominant tenement. C. Servient tenement. D. Licensed property. Answer, C. An easement appurtenant allows the holder of one property to benefit from another's. In this case, your property is servient because it is the one burdened by the easement while your neighbor's is dominant since it is the one that benefits. Quentin owned 2 acres of land. He sold 1 acre to Frank and reserved for himself an appurtenant easement over Frank's land for ingress and egress. Frank's land A. is the dominant tenement. B. is the servient tenement. C. can be cleared of the easement when Quentin sells the withheld acre to a third party. D. is subject to an easement in gross. Answer, B. Frank's land interest is the one burdened by the easement, therefore it is the servient property. Ginny owns 50 acres of land with 500 feet of frontage on a desirable recreational lake. She wishes to subdivide the parcel into saleable lots, but she wants to retain control over the lake frontage while allowing lot owners to have access to the lake. Which? A. An easement in gross. B. An appurtenant easement. C. An easement by necessity. D. A license. Answer, B. Appurtenant easements afford the most protection since they are generally a permanent feature of the property. Thus, in the case of sale, the lake access passes to any new owners. By contrast, an easement in gross is between 2 individuals, which would severely limit the attractiveness and value of the property if the original owner wished to sell. Sam and Nancy bought a store building and took title as joint tenants. Nancy died testate. Sam now owns the store. A. as a joint tenant with rights of survivorship. B. in severalty. C. as a tenant in common with Nancy's heirs. D. in trust. Answer, B. Joint tenancy means that 2 parties have an undivided interest in a particular property and, upon the death of one party, full ownership automatically goes to the survivor. Despite the way it sounds, inseveralty means as sole owner. When real estate under an estate for years is sold, what happens to the lease? A. It expires with the conveyance. B. It binds the new owner. C. It is subject to termination with proper notice. D. It is valid but unenforceable. Answer, B. Tenancy for years is the common form of rental agreements and binds all future owners for the term of the lease. Evan lives in an apartment building. The land and structures are owned by a corporation, with one mortgage loan covering the entire property. Like the other residents, Evan owns stock in the corporation and has a lease on his apartment. This type of ownership is called a condominium. B. Planned unit development. C. Timeshare. D. Cooperative. Answer, D. This is the distinguishing characteristic that differentiates cooperative from condominium ownership. Although often confused, a condominium owner holds title to his individual unit. A co-op owner, on the other hand, is technically a renter. It's his stock in the corporation holding title to the property that gives him the right to lease the unit as well as sell that right to another. Tom leases store space to Kim for a restaurant, and Kim installs her ovens, booths, counters, and other equipment. When do these items become real property? A. When they are installed. B. When Kim defaults on her rental payments. C. When the lease takes effect. D. When the lease expires, if the items are not taken by the tenant. Answer, D. Kim is free to move these fixtures at the end of her lease. However, if she chooses to leave them behind, they are considered a permanent part of the structure, just like a dining room chandelier in a home, and revert to Tom. Jim, Manny and Harry are joint tenants owning a parcel of land. Harry conveys his interest to his longtime friend Wendell. After the conveyance, Jim and Manny become tenants in common. B. Continue to be joint tenants with Harry. C. Become joint tenants with Wendell. D. Remain joint tenants owning a 2/3 interest. Answer, D. Because joint tenancy must be declared, Jim and Manny remain joint tenants with a 2/3 interest while Wendell, because of his passive acquisition of his share of the property, becomes a tenant in common with Jim and Manny. The difference between the two forms is that Jim and Manny's share retains the right of survivorship provisions, but Wendell's does not. In a gift of a parcel of real estate, one of the two owners was given an undivided 60% interest and the other received an undivided 40% interest. The two owners hold their interests as what? A. Cooperative owners. B. Joint tenants. C. Community property owners. D. Tenants in common. Answer, D. In order to create joint tenancy, some form of relationship must exist between the parties involved, whether business, spousal, or other. Because their interests were acquired as a gift, the parties in this instance become tenants in common, with all the ownership benefits of joint tenancy, but not the survivorship rights. To create a joint tenancy relationship in the ownership of real estate, there must be unities of A. Grantees, ownership, claim of right, and possession. B. Title, interest, encumbrance, and survivorship. C. Possession, time, interest, and title. D. Ownership, possession, heirs, and title. Answer, C. This essentially means that all parties to the agreement share equally in all aspects of the property, including the length of time it's been held. That means if one party sells or transfers interest in a joint tenancy relationship, his or her place is taken by another in the same capacity. What is a schedule of exceptions on a title policy? A. Encumbrances. B. Tax liens. C. List of things not insured in the policy. D. Defects. Answer, C. Almost no title insurance policy protects against all conceivable events. As the name suggests, the schedule of exceptions is a specific list of items not covered and can include things such as unrecorded mechanics liens, assessments, water rights, and mining claims. When a company furnishes materials for the construction of a house and is subsequently not paid, it may file a deficiency judgment. B. Lease pendens. C. Estoppel certificate. D. Mechanics lien. Answer, D. A mechanics lien is the first, and usually most cost-effective, step for a person providing labor and/or materials to a homeowner to recover monies owed in large part because of the pressure it puts on the homeowner to settle quickly and without costly court involvement. Which of the following liens does not need to be recorded to be valid? A. Materialman's lien. B. Real estate tax lien. C. Judgment lien. D. Mechanics lien. Answer, B. The requirement for individuals to record liens is due in part to the necessity of correctly identifying the complainant. For example, not just Jones Contracting, but the specific Jones Contracting that performed the work and is owed the money. Because they bear the authority of government and are easily identified, liens by taxing authorities do not need to be recorded. The system of ownership of real property in the United States is what? A. Incorporeal. B. Allodial. C. Inchoate. D. Feudal. Answer, B. Allodial is the modern form of ownership and is often contrasted with feudal, in which land is held on the condition of rent or service due the government. For example, a medieval knight held property subject to coming to his baron's service when called. Similarly, the baron's land holdings were conditional on his raising an army and fighting for the king in times of conflict. Failure of any party to perform as promised was cause for holdings to be confiscated, often as a preliminary step to more extreme actions.